What are the advantages and disadvantages of leaving assets to a child in trust or outright? When deciding whether to leave assets in trust or outright to a child, there are many things to consider. Although there are some exceptions, trust assets generally are not marital property in the event a child were to divorce. By contrast, assets distributed outright to a child potentially would be available to a spouse in the event of a failed marriage. For example, in Pennsylvania, the appreciation on assets a child inherits outright or could withdraw from a trust after reaching the specified age generally are treated as marital property, even if the child keeps the assets in the trust or in the child's sole name. Trust assets generally are not available to creditors a child might have. This includes not only debt creditors, but also accident creditors and malpractice creditors. By contrast, assets distributed outright or that a child could withdraw after reaching a specified age would be subject to the claims of a child's creditors. In a trust, you can specify how trust assets are to be distributed at the child's death. So, for example, you could decide that the trust assets must be distributed to your grandchildren at the child's death. You can give a child the power to decide the terms in trust or outright on which those assets will pass to the grandchildren. Or you can give the child broader powers, including the power to leave trust assets to any beneficiary. By contrast, if the assets are left outright to the child, you'll not have any say on where they will go. A child may serve as a co-trustee within certain limitations as sole trustee of a trust for the child's benefit. There can be some modest income tax advantages to leaving assets outright rather than in a trust. Special considerations apply in deciding whether to hold certain assets in trust, such as retirement accounts. For example, interest in 401k or 403b plans, or IRAs or Roth business assets or real estate. If you're interested in learning more, please call us at 610-897-8994 to schedule an appointment today to get started. I thank you for your time, and I look forward to helping you achieve your estate planning goals.